So I have two suggested changes to California's recall law. You know what? When I read about another recall effort being launched in February of 2024 against California Governor Gavin Newsom, it prompted me to review the provisions of Article 2 of our state constitution that provides for the three forms of direct democracy: initiative, referendum, and of course, recall here. Now, that review of the constitutional provisions in Section 2 prompts me to recommend two changes, actually three, because one is a repeal, and two new provisions to our state constitution to limit the potential for abuse, I believe, and hopefully save considerable taxpayer funds, while also preserving the ability to recall state officials. Now, to put things in context for you, Article 2, Section 13 of the California Constitution simply provides that recall is the power of the electors to remove an elective officer. As readers will recall, there was a recall effort that was successfully placed on a special election ballot that was held on September 14th of 2021. Now, that recall effort, which failed miserably by a margin of 62 to 38, cost the state and local governments in excess of $200 million to conduct. Of course, Gavin Newsom went on the following year to win a second and final term in November of 2022 with 59% of the statewide vote. Now, with reports of another recall effort being launched, I was reminded of the current 6-month rule that's contained in Article 2, Section 18, which was added in June 1976 by Prop 14. It says, "A state officer who is not recalled shall be reimbursed by the state for the officer's recall election expenses legally and personally incurred." Second clause says, "Another recall may not be initiated against the officer until 6 months after the election." Now, this particular section of Article 2 only applies to statewide officers. Those are the 9 constitutional offices, including the State Board of Equalization. And it's the second sentence contained in Section 18 that should be amended in my view. I would make 3 changes. First, the current 6-month prohibition should be repealed. Otherwise, from my perspective, a statewide officer could face multiple recall special elections over the course of their term because the current provision allows repeated recall attempts regardless of their likelihood of success or their cost to the state and local governments. Second, in order to address this concern, a new provision should be added to provide a new limitation that a recall could only occur once per 4-year term for a state officer. In other words, during a state officer's 4 years in office, he or she should only have to face one recall ballot. This would balance the recall rights of the people with costs of potentially repeated recall attempts. Third, a new provision should be added to provide that a recall cannot occur if less than half of the state officer's term is remaining. In other words, if the state officer has already served over half of their term, and the officer is either facing re-election or a term limit in that office, there's really no justification for a recall to be on the ballot at that time. That is because the voters will have their say soon, again, if the officer is standing for re-election, or the state official will be out of office soon enough to not warrant the time and cost of a recall ballot. Now, as a result, my proposed changes in Section 18 would make the first clause about reimbursement, subdivision A. We would strike the 6-month prohibition. Subdivision B would be added. It would say that a recall of a state officer shall not be initiated more than once during the term of that officer. And then I would add subdivision C that says a recall of a state officer shall not be initiated if the state officer has served more than half of that officer's term. Now, of course, these changes would have to be placed before the statewide voters for their approval, either by a constitutional amendment proposed by the legislature or by an initiative measure in order to amend Section 18 of Article 2. Also, this proposal would not affect impeachment provisions for state officers under Article 4, Section 18, which applies for alleged misconduct in office.